thank you all for introducing yourselves a little bit in the chat. Really, really excited for today's training. But before we get into it, I'll just pass over to Ravi to introduce our partnership.
All right. I can hear myself, but I'm just trying to organize myself a little better. And here I am. So hello, everyone. Thank you so much for joining. First of all, I wanted to give a shout out to everyone who I invited who joined. And there are so many people, Olivia, David, Marco, and I know there are more people who are joining and it might take some time. But thank you so much for your time. I really appreciate it. So I am one of the co-founders of the Global Green Recovery Collaborative, and I'm co-leading it with Rosalind Helfen. She's also in the chat. She's from the USA. And we have Janet, and we have so many more people from the collaborative. We form partnerships with initiatives from all over the world so that we can see what are the different elements of green recovery, as an example. Just to be quick, we formed a partnership with the ICAAD through Priya, who is also in this chat. We are friends, and then it was an informal discussion, and it eventuated into a formal meeting, and then we have multiple meetings, and now this is our very first joint event. So I just wanted to let you know that while we are looking at this amazing presentation on climate displacement and dignity and human rights, we also think about the word green and the word recovery. And we'll have a short video in the middle. And in that video, we'll use one of our other initiatives and partners who is also here from Australia. And we'll give a little bit human element to our partnership. So thank you so much for joining. Really appreciate it and looking forward to this session. Thank you.
Awesome. Yeah, so excited about this partnership and how we can weave these threads together. We have a very exciting agenda for today, but I'll start by introducing myself. My name is Erin Thomas. I'm zooming in from Auckland, New Zealand, and I'm a director and change facilitator at ICAAD. We are an international human rights advocacy center, and today is a very exciting day for us because we are launching some really cool advocacy tools, and you all are kind of the first to hear about it. We did send out our press release about an hour ago, but this is a really special event for us as well. So really happy to share it with you. My background is in the critical social sciences, research in the gender-based violence space, specifically in the Pacific. So it's handy to be out here in New Zealand. I know there were a couple of people in the chat also zooming in from here, which is exciting to see. So today we have a 2-hour training together, but if you do have to pop off after the first hour, we'll spend most of the second half having a bit of a fun quiz to review what we've learned, as well as doing a bit of Q&A and discussing where to from here. So it is being recorded, so we can share that recording if you do miss any part of it, but the first half will be most of the content. Today is also going to be very interactive, so really hope that you all can participate actively in the breakout rooms. Part of our methodology being design justice means that we want to take advantage of every opportunity to build our movements. And we know that movements are built with human relationships. So hopefully you get to meet some new people today, in addition to learning a lot about international law and climate mobility. I'll just go over a couple of Zoom tools as well. If you are not speaking, I'll ask that you mute your mic, which is just really helpful for everyone to hear clearly. We'll also have opportunities to speak and voice questions. It won't be a formal webinar per se. So for the Q&A, you're welcome to come off mute and share comments about your experience and questions that you have, maybe things that we can clarify. And then obviously in breakout rooms, plenty of chances to discuss with others. We might use the raise hand feature, which you can find in the reactions icon in your toolbar. And we'll also use that chat. So the chat's a great place to ask questions throughout today's training, as well as to offer any comments or thoughts on your experiences. At the end, we'll use this tool called Mentimeter. And so you'll need to either connect on your phone, or you can also do it on your laptop to participate in the quiz, but we'll go over that then. Now, today we also have some goodies for you. So at the end, we'll be sending out the advocacy briefing and the working paper, which are fresh off the press, and some great tools to take forward this learning. If you learn in different ways, if watching a training or participating in today's workshop isn't enough for you and you want to read it, we have that advocacy briefing that's just come out, which is an abbreviated version of the full working paper, which is an update on our project and covers everything that we'll be talking about today. So lots of exciting stuff to share with you all. I will also say all of the knowledge that we build today, I'm a humble facilitator in offering this knowledge to you all. This comes from our ICAAD team and our many collaborators on the climate front lines and from climate activist communities. And we're very honored to hold that knowledge and to share it with the utmost integrity to the best of our abilities to share out that knowledge and ensure more advocates are able to use it and leverage it for more equitable futures. So all of that being said, I wanted to frame our discussion by sharing what we do at ICAAD and also framing us up a little bit to talk about climate mobility. And then we'll go into a bit of a breakout to hear more from you about why this topic matters to you. So we do a number of things at ICAAD. We focus on capacity building, advocacy and reform, and human rights education, which are sort of the key tenets of this project, our Right to Life with Dignity project around climate mobility and international law. But we also work in the data and emerging tech space, as well as artivism. We're lucky to be very relationship driven in our work. That's how this partnership started with GGRC anyway. And able to support our grassroots partners where we can. We are an international NGO, so our goal is to leverage the technical expertise and pro bono resources we have from tech and law firms to amplify the amazing work that's already happening on the ground, which I'm sure many of you are already engaged in. I'll give some examples of the projects that we've worked on to show this connection between climate mobility and international law. So our first longest standing project in the Pacific Islands, which is where most of our work is because of those relationships, is our Track GBV program, which looks at analyzing sentencing decisions of gender-based violence cases to identify judicial bias and gender discrimination. This has actually emerged into a full data dashboard, which we use to offer trainings to stakeholders, both CSOs and lawyers and judges, to be able to implement that in their work. Sarah, I might just ask if you can mute folks who may accidentally come off mute as I'm going, just so we can hear clearly. I know there's some closed captioning going on as well. Another project that's quite relevant is our collaborative strategic assessment that we did with the Compact of Free Association states. So that's Micronesia and the Marshall Islands, as well as Palau. And the way that we went about doing that using design justice principles and bringing in grassroots collaborators is really reflected in how we've done this Right to Life with Dignity project as well. And actually how the organization started was supporting asylum seekers in the US. So our colleagues Hanseep and Jaspreet, who are unable to be here today, they're human rights lawyers and actually represented a number of Fijian women seeking asylum in the US over a decade ago, which led to some really exciting partnerships with the Fiji Women's Rights Movement and other amazing advocacy groups in the region. And then we also are kind of steeped in this intersection of climate change and human rights with this focus on legal implications. There's so much amazing work going on the ground towards a green recovery, towards climate justice, and sort of the niche that we found ourselves in and a way that we can be in service of these movements is by providing that technical knowledge and expertise, not just in the legal space, but in the multidisciplinary space in which this legal technical expertise sometimes is left out because we put it in the too hard basket, and we trust what lawyers say through and through and think that that's be all end all and we can't actually change anything. So really excited to be sort of at the stage of sort of pushing the boundaries on what's possible when it comes to international law in particular for this project. Now, to frame us up when we talk about climate mobility, now the impacts of the climate crisis have already led to migration and displacement, as many of us know, and not to mention the anticipated impacts. And we can use the term climate mobility to broadly describe the movement of people due to the impacts of climate change, as well as the barriers to such movement. And it's important to note, as we're mainly talking about cross-border, cross-international border migration today, because we're talking about international law, that actually most climate mobility, most climate migration will take place within internal borders and will only be temporary movements. So that's really important for us to keep in mind, especially when we think about what equitable futures look like and what we need to be doing as advocates to ensure that those protections are in place. The reason that we're focused on cross-border migration, one, is because it sets that international standard that can then be applied to different types of climate mobility. And two, because it's kind of the trickiest, thorniest aspect of climate mobility. And that's for a number of reasons that we'll actually go through now. So what I wanted to bring up, I know lots of people are already having conversations about climate mobility and what it means in their different contexts. I wanted to raise some of the key sort of conceptual themes for us to understand emerging from our climate frontline collaborators. So as a part of this project over the last 2 years, we've been engaged with climate frontline communities and climate activists as key collaborators on this project. There are 44 in particular who we've been working with, whether that was through discussions, feedback, informal chats, and so on, to help inform the direction and the accountability of this project, which is really key. So what I wanted to do is actually frame some of these themes for us as we go into our more heady content. So the first is global imperialism and racialized immigration policies. It's really important when we're talking about international borders that we come back to who drew the borders. A lot of the problems actually emerge before we even have the conversation about who can cross and under what terms. The modern contemporary concept of the nation state and how their borders are enforced are largely often based on racial distinctions to sort of maintain a national identity based on race, particularly in global north countries. So we think about strict immigration policies and how that actually entrenches global imperialism. So when we're stepping into this conversation about climate mobility and international law, we really want to come back to the roots of what we're talking about so that we can make sure we're expanding legal protections in a way that's as equitable as possible. Also importantly, for many of our collaborators who are climate activists, fighting climate inaction and extractive industries is a priority, right? And climate displacement is a devastating consequence of inaction on that front. When governments prioritize unfettered economic growth over people and the environment. It's also important for us to remember that while conversations of climate mobility are really important and people need to be having them, we also have to recognize that they often involve acutely traumatic realities for climate frontline communities, especially for Indigenous communities who have deep spiritual and ancestral connections to the lands and seas. These are questions about national identity, about cultural identity, about ancestry, lineage, heritage, and the climate crisis is threatening all of those very foundations. So we're holding all of this with a lot of care as we think about what we're actually talking about, even when we talk about climate mobility at a high level. Collaborators also wanted to raise the fact that there's a gap often between people and politics, which many of you might be familiar with. They identified that there's this disconnect often between what constituents want and are calling for in terms of actionable policy and climate around climate change and the rhetoric advanced by governments. So as an example, constituents in the country might be interested in advancing a bilateral pathway for cross-border migration between their country and another country. So they'd want their government leaders to pursue that along diplomatic lines, but maybe the government is more concerned about brain drain or is fixated only on internal relocation and not open to other possibilities. So we want to hold this tension as well and think about sort of this gap and hold all of this information being aware of what's going on. Now, the last two here that we want to keep in mind is that climate migration will always involve economic factors. I think it's common for thinkers in this space to think about climate migration as a very specific thing. But if you ask someone who's migrated, climate is often just one of many multiple reasons for migrating. And this is also in the context, right, of global imperialism and the colonial legacies of extraction and underdevelopment that leads to, for example, having access to higher incomes in the global north, right? And there are all these factors at play that we can't lose sight of, even when we hone in on the intersection of climate mobility and international law. That being said, these are all things that have emerged from our collaborators, and we'd love to hear from you. One thing that's been really important for us in building movement space around this issue is coming back to this why, this very personal why of what connects us to this issue and why it's important to us. Noting that a lot of this, it might touch on traumatic realities. Please share only what you feel comfortable with. But what we're going to do is go into some small breakout rooms. We'll just take 5 minutes here to each share for a minute or less an introduction to who you are, where you're calling from, and why climate-induced displacement matters to you, or why you're here today. So we'll make sure everyone can go. We'll just take about 5 minutes here in our breakout rooms. And we'll see you back in 5 minutes. Awesome. Welcome back, some of the groups. We'll just wait for the rest to join after all the breakout rooms have closed. But feel free to share in the chat some of the things that came out of that short discussion, noting that you will go back into those breakout rooms, so you'll have more of a chance to talk with one another in a bit. But as you're coming back, share in the chat what stood out for you, what were some of the reasons, some of those connections. Awesome. Welcome back, everyone. I think that's everyone back in the room. As I introduce our next section, just drop in the chat anything that stood out to you from that breakout discussion about some of the reasons why this topic matters to you. And I'll just get our mute going. Awesome. Very good. Cool. So drop those into the chat. As I go into this next section of content, this is going to be a wild crash course on international law and climate mobility. People do whole courses of study. They make their whole careers around this topic. So what we're going to be able to cover in about 20 minutes will be brief, and it will be quite high level. The goal is to give you some context and some language for actively participating in these conversations in the future. And as I mentioned, we'll share out that advocacy briefing and working paper for you to reference later as well. In the chat at the beginning, a few people mentioned that they're looking to gain more understanding of best practices for well-being or resilience as it relates to people displaced by the climate crisis. I will just note that this will be quite high level. For the purposes of today, we won't quite go in that direction. We're going to stay at this international law level. But I do know a few people working in that space in the Pacific, if anyone would like those connections. And my email address is in a few places, but I'll also send you all an email after this. So if you'd like to have a chat about anything more specific, or if I can connect you to anyone, that would be, we can follow that up later. Awesome. Yeah, so it sounds like some people are already having conversations around climate relocation and all of these complexities to land and people and community. A lot of our conversations with our local collaborators are also along those lines. It can get really, really complicated. Yeah, and because it's personal, there are lots of reasons why we feel connected to this issue. And I hope you were able to hear some other issues and maybe find some similarities between you and other folks on the call today. Now, I'm going to go into this crash course on the legal context for the protections of climate displaced persons by going over just a few of these provisions. So we could do a whole overview of refugee law, a whole overview of international human rights law, but what we've decided to do today was go into almost a literature review of some of the gaps that exist as it relates to the human rights of people displaced by the climate crisis, as well as a couple of recent decisions that have created an opening that we've seen around this right to life with dignity, which we'll get into in a minute. And we'll also talk about the right to a healthy environment, which is a more recent non-legally binding development in international law, which can give us some momentum. And we'll have a brief coming together in your breakout rooms to talk about what stood out from this content. And then we'll talk about where to from here and what we're proposing to fill in some of these gaps. So this is the part where you might want a pen and paper to jot down any notes or any questions that come up. There will be a quiz at the end, but there's no failing grade. Just as a way to keep engaged for a short period of time. We won't take too long for this content here. Now, starting us off, there's been a lot of conversations about climate refugees. Now, for a number of reasons, people don't like this framing. People displaced by the climate crisis often don't like this framing because it comes back to that vulnerability framework. It comes back to sort of that marginalized identity. And also in an international law context, the Refugee Convention is not quite suited for what we're talking about with climate mobility. Now, to frame us here, the Refugee Convention was passed in the aftermath of World War II and the mass violence and displacement within Europe as a way for countries to come together in solidarity at a time of urgent humanitarian need. And now the key legal concept in the Refugee Convention is non-refoulement, which means sort of under this law, you cannot send someone away who is seeking asylum in your country when there are strong reasons to believe they could face serious human rights violations. And so there are some terms of this, these convention grounds. So if they potentially face persecution based on the grounds of race, religion, nationality, political opinion, or membership of a particular social group. That means that if you seek asylum, you have to make your case on these grounds for non-refoulement, so to not be sent back. Now, we're gonna talk about two major cases. So there's the Tessiota decision and the Torres Strait decision. I want to just touch on this one first because the Tessiota decision in 2020 invoked the Refugee Convention first through all of the New Zealand courts. So Ioane Tessiota and his wife migrated to New Zealand in 2007 from Kiribati, an island in the Pacific. They wanted to start a family and believed there would be no future for them in Kiribati, largely as a result of environmental degradation and the impacts of climate change. So after their visas expired in New Zealand, they applied for refugee status for their family based on grounds of the impacts of climate change being connected to this provision of non-refoulement in the Refugee Convention. Now, this went up the courts in New Zealand and was rejected each time. But there were sort of openings each time around this gap of, it doesn't seem like the Refugee Convention is suiting the needs of people displaced by the climate crisis. There are a couple of reasons for that. One being there's no human agent for the persecution, right? So the convention grounds of persecution based on race, religion, nationality, political opinion, and membership of a particular social group, there's no grounds there under that piece of law, and there's no human entity where that clear link could be made. We can argue that carbon emitters are doing the act to then create the persecution, but those links aren't clear. And while there's sort of case law around and precedent for considering conflict and violence in the Refugee Convention, it didn't quite apply, and they couldn't quite thread the needle in the New Zealand courts. This case was later brought to the Human Rights Committee, which we'll get to in a minute. And that decision created some openings in broader human rights law, which we'll talk about in a moment. But just wanted to acknowledge some of these gaps here first. Now, there have been efforts to expand this definition of a refugee, noting that times change, circumstances change, and there are different humanitarian needs that arise. So there are two declarations here among a couple of other sort of regional policy efforts to expand the definition of refugee to include other things. So we have the Cartagena Declaration, which was in 1984 by the Colloquium on International Protection of Refugees in Latin America. And it was adopted to expand the definition of refugee in the spirit of solidarity and cooperation. So they did so to include people who fled their countries because they've been threatened by generalized violence, foreign aggression, internal conflicts, massive violations of human rights, or general circumstances that seriously disturb public order. This was also done in 1969 by the Organization for African Unity, who put out this regional policy, similarly expanding this definition. Now, this notion of seriously disturbing public order could potentially be invoked as a result of a climate event, right? We can kind of see how that argument might be made in a case to expand the definition of refugee in the convention as it stands, but these are regional policies, so they haven't quite altered the actual international standard. And they would have to be argued and perhaps set a new precedent in order to be invoked. And no one has quite yet attempted or successfully attempted to include the impacts of climate change in the Refugee Convention. There is also this effort in the European Union, the European Council Temporary Protection Directive, which is a temporary provision, so outlines standards for temporary protection of mass influxes of displaced people. Importantly, this still does not cover environmental conditions. So we can see how there's been attempts to make change responding to urgent need, But again, challenges remain. So what we see is one, that the convention is reactive. We understand what some of these impacts of the climate crisis will be, and the way that the convention is framed doesn't address migration as adaptation to slow onset environmental degradation. It also doesn't apply to the vast majority of those displaced by the climate crisis who move within borders, right? So we still kind of need a standard to cover climate mobility more broadly. And further, thinking about sort of the legal components of this, actually opening up the Refugee Convention and really gutting it and reassessing the entire convention risks its renegotiation. And many countries have sort of shifted opinion since 1951 on exactly what they'd want in a refugee convention. And there's been a lot of resistance from powerful countries around applying and implementing its provisions. And many fear opening it up to renegotiation, given that it could risk all of the provisions entirely, and even in its attempt to expand it in a positive direction. And finally, we can see how this causation and sort of human agent of persecution is difficult when it comes to climate displacement. It's difficult to make that argument, and we've seen attempts made that have not successfully done that yet. Now we're going to shift into international human rights law. So a little bit away from refugee law, which is under the camp of humanitarian law as a category of international law. And we're going to look at human rights law. So here, you all have probably seen some of these treaties before. I know they're quite small, but what we're going to talk about here, this core set of international human rights treaties, we're going to focus in on the International Bill of Human Rights, which is this circle of three here, including the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights, alongside the Declaration, Universal Declaration on Human Rights. So again, this constitutes the International Bill of Rights. These core texts lay the foundation for the rest of the treaties here that provide greater specificity on topics. For example, CEDAW, the Convention on the Elimination of Discrimination Against Women, and protections for persons with disabilities, and so on. The other treaties get more specific, but we're going to focus on the Bill of Rights and specifically ICCPR, so the Covenant on Civil and Political Rights. You all might be familiar with this. There are a couple of rights here that we will focus on in particular as it relates to two really important decisions. So Article 6, the right to life. As we have alluded to, the right to life with dignity is the focus of our proposed legal standard. We also have Article 7, which is freedom from torture. Article 17, the right to privacy, family, and home. And Article 27, the right to culture. Articles 17 and 27 were invoked in one of the other cases we'll talk about. And Articles 6 and 7, importantly, are ones that should not be interpreted narrowly and are invoked with non-refoulement. So basically, states cannot deport individuals if doing so breaches Article 6 or Article 7, that right to life and freedom from torture. Now, states also have a positive duty to address general conditions that may prevent individuals from enjoying this right to life, with dignity being sort of the underpinning spirit of the law. And there are general comments from the Human Rights Committee, sort of guidance or advice on how to apply this, that state protections required for Article 6, this right to life, may be broader than the scope of non-refoulement under refugee law. So again, we're kind of starting to see some of these doors crack open, or possibilities of directions we can go in to ensure that people displaced by the climate crisis are protected. Now, one of these general comments from the Human Rights Committee, again, sort of legal guidance for the committee as they make decisions that come before them, states that environmental degradation, climate change, and unsustainable development constitute some of the most pressing and serious threats to the ability of present and future generations to enjoy the right to life. So Article 6. Now, other comments have stated that the right to life should not be interpreted narrowly, and that it may be invoked when it comes to climate change, which is really important. And our ears perked up at that when we saw that come through in those general comments, as well as in the Tessiota decision when they were referenced. So we come back to this case, Ioane Tessiota and his family in New Zealand seeking asylum. They were rejected by New Zealand courts, and they brought their case before the Human Rights Committee. So the Human Rights Committee oversees the ICCPR, Civil and Political Rights Covenant, via the optional protocol. So basically, there's a protocol for people to send claims to if their case was sort of rejected at every stage domestically. So this is what happened. All of those New Zealand court cases were overturned or rejected. Then they were able to bring the case to the Human Rights Committee at that international level. So this is one of the two cases that we want to talk about today. Unfortunately, the committee still rejected this application, right? They stated that while climate change may expose individuals to violations of Article 6 and Article 7, triggering non-refoulement obligations on the state, that still the ability of the Kiribati government to act in order to reduce the risk of those violations was high. So for example, he had made the argument that sea level rise, salination, was affecting their livelihoods, their ability to access housing, and to access clean water. Basically, the committee said that there's time for the Kiribati government to act for climate adaptation in order for those risks to be mitigated completely, so that the Tessiota family, their rights would not be violated should the Kiribati government be able to act. So the Kiribati government was given a lot of leeway in terms of their ability to act, but there were still dissenting opinions from judges on this committee stating that there is potential for violations of their right to life with dignity. Now, we'll come back to this in a moment about what this with dignity piece does in terms of Article 6. But there's another case that we want to touch on here, which is the Torres Strait decision. So in May of 2019, a group of 8 Torres Strait Islander people submitted a complaint through the same optional protocol to the Human Rights Committee, alleging that Australia failed to protect them from climate impacts, which resulted in multiple violations under the same covenant, under the ICCPR, the right to life, the right, Article 17, so the right to be free from interference with privacy, family, and home, and Article 27, the right to culture. This was the first legal action brought by Indigenous peoples of low-lying islands against a state, and the first climate change litigation brought against the Australian federal government on human rights grounds as well. Now, importantly, this case does not concern cross-border migration. So the committee doesn't explore Article 6 in the same way that it did in the Tessiota case. This was more about Australia's obligation. When we saw the Tessiota case, it wasn't looking at New Zealand, it was actually looking at the Kiribati government. So we see a little bit of a difference between these decisions, but still the analysis around Article 6 points to some important insights for us as we go forward. So again, it's a domestic issue, but still we see how the authors of the complaint outlined many of their concerns related to Article 6 related to dignity. So the authors detailed their feelings of insecurity, endangered by like a loss of predictability of seasonal weather patterns, of seasonal timing of tides, of availability of traditionally and culturally important food sources, among many other causal arguments between the impacts of climate change and their right to life with dignity. Now, the committee again did not find an Article 6 violation, but they largely grouped these claims, this link of culture and dignity as it's related to right to life, under Article 27, which is the right to culture. So basically, they agreed, in essence, that there was a right to life with dignity violation, but they couched it under Article 27. And the reason they might have done that is because Article 6 is incredibly powerful and would invoke that non-refoulement provision, meaning that if this were a cross-border case, that their rights potentially could have been protected and they would be granted visas or asylum to stay. So importantly, we learn a lot from this question. And we also come back to state accountability. So in this case, a similar argument was made about the fact that the Australian government could potentially act to reduce the risks. They could build seawalls or actually meet the deadlines for their climate adaptation strategies that they put out. Because they had not adequately and met those obligations to adapt and to respond to the needs of communities, it actually put their accountability in question. And that was why the committee decided in favor of their violations under those other articles. So there is a world in which the state not meeting their obligations, not meeting their positive duty, could actually put them at fault for these violations. Now, this is still an issue because it's a narrow risk threshold. Basically, when we think about risk, they're still using the precedent in refugee law in the sense that there is an imminence factor, so it needs to be pressing and happening right now, and the risk and the likelihood that it happens needs to be incredibly high. Because there's no clear evidentiary standard or set of reasoning that people need to put forward to basically build that argument that it is an imminent, real, and foreseeable threat, it's difficult. And the committee then can respond in different ways to say, actually, it didn't meet that threshold because it's so vague. Now, what we respond to with our proposed legal standard is actually an evidentiary standard that responds to this gap. And we'll get to that in a little bit. But importantly, that standard also includes a more substantive definition of dignity. Now, the role of dignity in international human rights law is a legal and political question that has animated many discussions since the very creation of the Universal Declaration of Human Rights. If you sit and think about what dignity means to you, we'll all have varying definitions, right? And its purpose is actually functioning to adapt more rigid definitions that are set out in the human rights framework in order to meet the needs and extend rights to those most vulnerable and whose human dignity is imperiled, even when it doesn't acutely and accurately meet what those rights violations are. It underpins the spirit of the law in essence and can be used to stretch different provisions of human rights law where needed. Now, this seems like a great opportunity, right, to meet the needs of people displaced by the climate crisis and leverage this component to hear what people are saying on the climate front lines about their dignity and their right to life being threatened, and to actually set the terms at which those cases might be adjudicated. Importantly, too, this concept of dignity is also culturally specific and actually meets the needs of different groups. So they're able to make arguments that make the most sense to them. For example, in the Torres Strait case, where the group actually made the complaints around losing access to traditional and culturally significant food sources, and that was a key component of their right to life with dignity. Now, I know we're rushing through all of this a little bit. I hope you're still with me. I just wanted to flag a legal development that's showing sort of a promising direction along these lines. There are many conversations, there are many efforts to really think about how we can advance a more rights-based approach to climate mobility, and more broadly, honing in on what that intersection of climate justice and human rights actually looks like in human rights law. And this development of the right to a safe, clean, healthy, and sustainable environment is really promising. So this was passed by the UN General Assembly in July 2022. Although it's non-binding, it is a strong basis to connect other legal provisions, right? In the resolution, they identified that this right to a healthy environment is important for the enjoyment of other rights. So connecting it to something like a right to life with dignity could be really helpful in essence. So relating it to other rights and existing international law. And the right itself includes the right to clean air, a safe climate, access to safe water and adequate sanitation, healthy and sustainably produced food, non-toxic environments in which to work, study, live, and play, and healthy biodiversity and ecosystems. When we think about the Tessiota case and the Torres Strait case, this right could actually be added to those arguments in order to underpin what a right to life with dignity could look like. And it also gives us a sense of hope for what's happening at the international law level to advance some of these conversations at the highest levels. There are still some gaps, and I'll just point these out before I talk about sort of where we fit in terms of our proposed legal framework and evidentiary standard. We know that existing frameworks don't suit climate displacement. We talked about how assessing risk and imminence was incredibly inappropriate based on refugee law. We've heard this sort of maybe through the grapevine, but we can also see it clearly in these cases, how that application doesn't make sense. And we actually need something new. We also see that while states have a positive duty to protect these rights, often they're given a lot of credit and given a lot of leeway in terms of, oh, they can adapt so that their rights aren't violated in a way that allows them to get around this obligation of non-refoulement or allowing people to cross borders. And we have this difficulty again of state responsibility to mitigate and adapt. States are still getting around this in international law, which is something that we're hoping to address. And we're still on this path to expanding international law so that we can have safe, dignified, and regular migration in the context of the climate crisis, which is the demand that's coming from climate frontline communities and the demand that we're really honored and proud to back. All right, that is enough talking from me. I hope you all are now experts on international law and climate mobility. I know that was a lot of information all at once. And so what I would love to do, and again, all of this will be in our advocacy briefing and in the working paper, so you can reference all of it, and we'll have the recording as well. But we'll actually go back into breakout rooms just to share out briefly with those same groups what was new for you, what stood out for you, and maybe what questions do you still have. So we'll try to get around the circle again, and we'll just take 5 minutes here. Oh, raise hand. Rosalind, do you want to?
Yeah, I just have a really, a really quick question. Okay, so I'm just to understand. So most people, when they're claiming climate reasons for leaving their countries, then they have to prove that they're being put into a position where they have to prove that that their country is not able to adapt. And if the country can't adapt, then they're at risk of being sent back. However, are there arguments being made right now in courts for moving to a country, for example, that is the imperialist historic high emitter or creation of the climate problem that then is impacting their country? So say if you're moving from a small island that's disappearing, and you can prove that the US created, or England, or whatever country it is, created like a certain percentage of the emissions that's led to this happening and is continuing to do so, can you use that as reason to A, leave your country, and B, to perhaps even move to the country that has that high level of emissions historically?
Yeah, that's a great question. And a question that's on a lot of legal minds. That those cases have not yet emerged. There are examples in sort of domestic judiciaries of that question of sort of accountability coming up, as there's a great Dutch case from a few years ago where the Supreme Court actually ruled that the Dutch government was in fact liable for their failure to act, for example, but that was still a domestic issue. No one's actually brought a case yet drawing those links out, even in terms of, like, the Tessiota case didn't bring out the fact that New Zealand is a major carbon emitter, even though they could have, if that makes sense. To give some context, in the Torres Strait case, within Australia, the Torres Strait Islanders making the complaint couldn't even get that accountability from the Australian government to say that their failure to act, it was only their failure to act in terms of adaptation, not their failure to act in terms of mitigation. and actually addressing their carbon output. So that's still an area to advance and definitely a key component of this. But that's a great question in terms of expanding legal protections, and certainly the direction that a lot of people are hoping to go in. Great question.
Thank you. And it sounds like the mitigation aspect needs to really be really pursued. So thank you for that.
Yeah, absolutely. All right, well, we'll go into quick breakout rooms here. We'll do another 5 minutes and we'll see you back here in 5. Go ahead and share out what stood out for you, what was new for you, and we'll see you back. Welcome back, everyone. We'll do the same thing where we'll just drop in the chat anything that stood out or came up in your group around this conversation. And maybe we have a minute just if anyone wants to come off mute and share with the whole group something that stood out.
Well, I'll just say that one thing that stood out to me at the very end of our conversation, we were talking about how if it just seems like because the need is so urgent now, and yet so many governments are pushing back more than ever, that it's funny, like the worse it gets, the more people are digging in on the worst possible response to everything. And so it seems like there needs to be some sort of more strategic, coordinated approach on what you discussed, and ways to work with the tools that we have for displacement.
Yeah, absolutely. Even reading some of the cases, it's like, was this 10 years ago? Oh no, this was last year, which is a bit, shocking, especially looking at all of the updated climate data as well. I will say I left on the gaps, and we will come to the legal standard and the evidentiary standard as well that we're putting forward, and some pathways for how we might implement that. So we'll come back to that in a bit as well. Feel free to drop in the chat anything else that stood out. Yeah, definitely. Existing gaps in the protections for the rights of people displaced. Totally. I hope this gave some context for folks to sort of continue these conversations and to be an active participant now in all of them. You don't need to be a lawyer to understand all of this. And hopefully we can all be a part of this movement and bringing this forward. Now we will come back to our quiz at the end, so it'll be a test of if you can remember all of this information. But now I'll hand over to Ravi to connect the dots for us to the green recovery.
Okay, thank you so much. So I remember mentioning right at the beginning to remember the two words green and recovery. So the Global Green Recovery Collaborative was founded on the idea that green recovery is a big redesign. And we started having conversations informally about green recovery during the COVID-19 pandemic when we were in lockdowns. And we knew that once the pandemic will ease, we will try to recover our economies. While recovering our economies, we wanted to make sure that we considered and actively protected our environment. So that's the green element. Recovery could mean multiple things. And in the context of our training right now on climate displaced people, I think that while we are talking about recovering our environment and recovering our economies, we also have a human element, especially when we are talking about rights and dignity. So I wouldn't talk much. I would like to use this opportunity to feature one of our most recent initiatives, which would, there's a video, and we may play the video, which also give us a little bit of a breather and a little bit of a human element to see how are the lives of climate displaced people or displaced people in generally going on in the background while we are talking about policies and practices and laws. So Tuj Ajak, he's also in this chat. He is the focal point for this initiative. He has co-founded it. And just to give a little bit of a background, Tuj is there. Tuj, would you like to just quickly say hi? Okay, he didn't hear me. So Tuj, if you can wave, so he's there. So Tuj comes from South Sudan, and he comes from Africa, and then he is one of the immigrants who had to be forced to go to another country, and which is Australia. And while he was there, he co-founded this farm where he could have African immigrants who could come together and have a sense of belonging And right now they're doing sustainable farming, so that while they, as immigrants in a foreign country, um, get together for their wellness and being, they also protect the environment and take care of it. So this is where the whole element of green recovery comes into play. We'll have a video played over here. While watching the video, while we have more questions, we could keep on putting it in the chat. And yeah, thank you so much. So we could just play the video directly. Thank you so much.
Within the African culture, we are raised as farmers. Back home, you have your own house, you have a small land that where you do gardening, so it's really very important to the community. Culturally, food unites people. And coming here, we lost that connection, that knowledge of farming, that connection to the soil. Also for people to have that freedom for them to grow their own food, for them to get connected to the land, touch the soil. All of that is therapeutics. My name is Tuch Ajak. I am the co-founder of the United African Farm. So I work here as a project coordinator. And also in the community, I also do a lot. I work at Asylum Seekers Resource Center too, and I run a community radio on Tuesdays.
This rice is a sign of peace, prosperity, progress. In our village, when there's an occasion, any joyous occasion, you see our people, they are throwing it. When big people come to you, you throwing it. Let God bless you. Open your way. What we are here to do, let it be peaceful. Yeah.
We come all across, so like you could see, I come from eastern part of Africa. I come from the west, which is Liberia. We have people from Nigeria, Liberia, Ghana, rest of the West Africa, which are involved in the farm. Also, we have the Sudanese, the South Sudanese, Kenyan, Ethiopian, Uganda. So it's sort of uniting. It's like the West and the East meeting together. I was born during the war that took 21 years in South Sudan. So my family and I fled to Kenya, which would settle in Kakuma refugee camp. So I went there when I was really small, like 10. That was in 1995. So throughout until 2006, that's when I left Kakuma refugee camp to go back to South Sudan. By that time, the peace, which is the Comprehensive Peace Agreement, CPA, has been signed. And I went back to the country to go, with my high school certificates. I went back to the country to go help, be part of the nation building. And that's when I got opportunity to go to university. So I went to university and studied agriculture, specializing in crop protection. So that was in the Upper Nile University. And then our country went to war again, which is in 2013, which was really quite devastating. And that's when I decided that, okay, it's better that I migrate to come to Australia to look for, opportunities to study, look for opportunities to work. And then I came here to this beautiful country in 2015. I got married here and started a family here. I have 3 kids. My mom is here with me now. And I've been in Melbourne since 2016. When I came to Australia, I didn't really get it that easy to get into the agricultural sector. So I started looking for farms on my own just to start a market garden. And by that time it was a bit difficult, and I was not much conversed with how farms work here and all of other details. And that's when I started first volunteering at Ceres, George Market Garden, to get the connection that I need. And then I started at my backyard. So I started growing some few veggies on my backyard in Caroline Springs. And that's when I met Mama Kuya, who was on the other side looking for the land to grow. And we joined together and founded what we call the United African Farm.
Yeah, come and eat.
Mama Kuya, she's a community mobilizer. She has a lot of cultural knowledge, a lot of traditional knowledge that we can learn from her. And also within the African context, we have that respect for the elderly and play a vital role in that, in connecting the community, in bringing the people together.
We're going to cook it here. We'll be running the cooking classes here. All of us back home in Africa, as children, as kids, just as my grandchild is, our eyes open on farm. We see our parents, we see our grandparents. All that we have to wake up to in the village is farming. If I will cook anything, I have to grow it. When I grow it, then I, pick fresh, and then I feel that I'm in my village, and then I can cook it. It's very much important because this is the taste that I know. It's fresh, it's healthy.
The farm is 3 acres of land, so it's divided into two main. So one is the community area, and this is the produce garden. So this is basically where we do the growing, and then the other part of the farm is where the community event, community festivals happen. From where I come from a tropical climate. If you put a seed down, you expect it to germinate in few days. But here, sometimes it's quite a challenge, like, putting in an order for seedlings, it takes you 8 weeks. The coldness doesn't really support some of the tropical crops to grow here. So we only have one window, which is the summer, and sometimes we might get them in, sometimes we may not. So that's been a bit of a challenge for us because crops like okra, mean so much, and we can put them in throughout, except only in the summer. And sometimes when it is a short summer, you may not harvest anything. People had to change what they cook and also to learn some of the few available crops that are within Victoria, that are within Australia, that they are not used to back home. Like Egyptian spinach, which is very common in our culture, we call it khudra. It's not easily found here, so we have to substitute it to either broccoli or kales in a place of that. We're going on a grace bed because we have an elderly populations that come here. It's easier for them to turn into the rice bed than when they grow straight from the land. Also, we had flooding here, so we're trying to raise it up so that we can have a bit of a production. Last year we had all this area flooded and we lost a lot of crops. This is a clay soil, so it's good, but we are in a lower part of the area. So basically when it rains, there's a lot of water that is stagnant here, and there's no good drainage system that we have here. What gives me joy sometimes, people coming here, finding purpose, working the garden, connect to each other, and also give a positive narration. You've seen a lot of media coverage about the African overrepresentations and all of that. So I feel like I'm giving back to the community. I feel like I'm also contributing in changing narrative and also to find opportunities for young people. Once you're born in the city, you don't want to get dirty, you want to look for this job and that. But there are people that are connecting back, that connecting back to the roots, that are connecting back to grow food, which is really quite exciting.
My hope for this farm is to unite us with the Australians. Australians, you are, and that's why we are, because we depend on each other. We depend on each other. We hold each other's hand. We are there for one another. So my future, my thinking, in fact, the picture that I'm looking at now is this farm is going to bring us together. It will break the fear. That fear is going to build more love.
I feel joy when I see that there's a progress. There's something that I'm contributing to the community. And that's why I keep doing what I'm doing.
Oh, awesome. Ravi, did you want to add anything else to that?
No, thank you so much. I was wondering, Tooch, would you like to very briefly say something? Thank you so much.
Thanks, Ravi and the team. I may not speak a lot because my kids are already at work. They're disturbing me. So yeah, so the United African Farm is it's a community initiative which is here, and it was founded in 2019. So we continue to engage the community, use it as an educational place whereby we talk various topics on climate, on other migration issues. And as you all know, migrating to a new country is not always easy. Either you were displaced by war or displaced by climate. Resettling to a new country, always there's a lot of challenges that come with it. And sometimes when you are dispersed in a city like Melbourne, you don't find each other. Sometimes you end up not getting the support that you needed. So having a community-centered farm, a space, a safe space for a community to come together, share the knowledge, you know, educate each other and helps each other throughout in integration process and all of that. We see it is more rewarding, and it's more appealing and more needing within the community. So this is why we started this farm initiative, and it's really growing. It's kind of small. We started on a 1 acre of a land in 2019. We lost that land. We got this land again. One of the local members felt that this initiative was really beneficial to the people, so he donated it to us, and we leased it. And so that's where we are at the moment, concentrating all our operations inside here in the southeast of Melbourne, and it's really bringing in young people. At the moment now, we have about 5 young people that are engaged, employed, and we are continuing to bring in more people so that they continue to learn more about their culture, continue to, discover what is there, what are some of the traditional foods, and all of that. So it's really quite captivating, and thank you, Ravi, for showing it today, and thank you everyone for listening to it.
Oh, amazing. Well, it's quite an honor to have you here with us to share just really an example of how to embrace a right to life with dignity in a community level. I think we're talking very narrowly about what happens at the border, essentially. But there's so much more to be said about how we actually cultivate community, how we ensure that cultural identity and cohesion is preserved when and after individuals and communities move and come together. So that was just amazing, and really, really grateful to have you and to have you share as well. Along those lines, I should say, I'll share a little bit about our project more broadly and what all of this looks like in practice. We're not always just sitting behind computers on Zooms and meetings, although I did include that picture because that's a large part of what this was, bringing together a lot of technical experts to do some of this thinking around the law, around data, and around obviously the social science and Indigenous research knowledge aspects as well. But this project centered on this right to life with dignity legal standard, but has stemmed off to some really exciting local projects that are connected to what a right to life with dignity actually means in practice as it connects to climate mobility broadly. So one example of this is actually supporting a lot of these similar conversations around what does community cohesion look like around planned relocations in Niue. So we have a really exciting project developing around proposing a national policy for internal relocation in Niue that honors the right to life with dignity. What does that look like in an internal context? We've also been working with our Bonabin partners on the island of Rambi, who've been displaced due to phosphate mining over the last century. And there are lots of legal questions there as well as it relates to human rights. So we're basically working in that same relationship-driven way that we do with all of our projects to ensure that this high-level thinking around international law can then stem through our local partners and support the work that they're doing. All of that being said, you now are in our network of advocates to receive some of these tools. And I'll just drop in the chat here the very exciting link to our advocacy briefing, which has just gone live. And at the bottom of that link is the working paper. I'll email both of these copies so that you all have them in PDF form as well. But this goes in depth of everything we talked about today and also talks about those next step pathways to support your work. There are footnotes as well if you want to go into further research, or if there are ways in which this can support your work in a more granular way. Happy to also be a resource in conversation about that. But I'll just briefly touch on this. I know we've had a lot of content today, so I won't dive into too much depth on the actual legal standard and evidentiary standard, but here it is. In essence, this is what we've put together with our climate frontline collaborators, with our multidisciplinary team at this stage for what we'd like to apply if, for example, there were to be a new Tessiota case. So we have the right to life with dignity standard. Essentially, what are the components of this? Emphasizing dignity as the key aspect of that, and emphasizing how it applies to climate displaced people. And then importantly, there's that evidentiary standard. I talked about how one of the gaps is how vague this is applied. And this is basically really honing in on what this would actually look like, what is a reasonable chance, basically detailing what that risk looks like, so the committee can no longer get around it. It also importantly includes complementary protection, which is really key for people whose dignity is connected to their relationships to their families, to their community members, in a way that's culturally significant, right? A lot of international law emphasizes the nuclear family, which isn't protecting rights for a lot of people. So that's a key component of that evidentiary standard so that people can move together. And then also importantly, advancing this is about shifting the burden of proof onto states. So now states, as I mentioned, they kind of get that leeway around climate mitigation. Part of this evidentiary standard is also ensuring that they have to prove that they're protecting right to life and dignity, instead of taking it as an assumption that they're already doing that and leaving it to the people complaining to argue that they did. So that is the legal standard, evidentiary standard. The working paper goes into a lot more detail if you're interested in this component. But if you're not in the law space, this might be less interesting. But I will say, in terms of the where to from here, a few people asked in the chat about sort of direction, are there coordinated movements and so on. The really obvious next step for the lawyers on our team is pursuing strategic litigation. So finding another test case like the Tessiota case and putting this legal standard and evidentiary standard into action. So that's one way that you can actually change law, by changing the precedent. And so by arguing a really strategic test case and getting this into precedent, so having a case decided in our favor, or an opinion even aligning with this legal standard, could be a really positive direction. There's also a lot of regional and national policy developments at play. We're really active in the Pacific regional climate mobility policy space, in ensuring that it's rights-based and promotes safe, just, and regular migration with dignity. And there's also somewhat of a coordinated movement started by the Special Rapporteur's reports in April to develop an optional protocol to the Refugee Convention. So there's a way in which reassessing or amending the Refugee Convention risks opening the entire thing to renegotiation, which people don't want. But there is some movement towards adding this optional protocol. Again, it reduces some of that legally binding good stuff that we want for countries who don't want to participate actively. But it can advance this conversation and this legal standard and evidentiary standard, and all of this work to date, and what we hope to continue to do, hopefully alongside many of you, is to advance these the right to life dignity as a key component of whatever comes next, whether it's under the category of refugee law, or what we're hoping for is connecting it to international human rights law, building on those gaps that we saw. Now, our next step is to continue this global legal analysis of dignity, and would love to connect with all of you on this point about what dignity means to you and how you see this legal standard developing in a way that represents your interests and what dignity might mean in your climate context. We're also moving forward on modeling climate data for the purposes of the evidentiary standard, so it could be used in strategic litigation or other policy developments. And we're looking at other implementation and advocacy pathways to look to protect people displaced on multiple different fronts. And we'll just briefly touch on where to next, since we are at the time of COP28, leading right up to it. And then I'll just briefly touch on some of the specific climate frontline demands to cap us off before we go into our quiz. Robbie, did you want to start with the connection to COP28?
I'm good. I'm just trying to extend an invitation if Ross wanted to contribute something. If not, then we could just go ahead. Thank you. Or anybody else.
Sure.
Hi, I'm happy to say a few words on the connection to COP28. So this is Rosalind Helfand, one of the co-founders of the Global Green Recovery Collaborative. And this is obviously incredibly important for COP28. One of the ironies being that where COP28 is being held in the UAE is considered to be a very at-risk country for sea level rise due to climate change and loss of habitable area, and yet it's also a major oil-producing nation. So there are some really interesting questions there as well. But and I know that some organizations from island nations have decided to boycott COP because they just don't see enough action being taken. And I think all this goes together to say that we're really coming to a head with the global stock taking place at COP28 on how exactly we're going to move forward and meet the needs of people. And I think that this conversation is absolutely critical to that. And it really is evidence of the inequity that we see between a lot of countries in the COP space. However, whatever comes out of the negotiations, I think that we're going to see some really important discussions and hopefully movement forward that take place on the sidelines of the negotiations. And amongst those who are present, and I know there will also be virtual spaces. For example, there's going to be a climate law and governance conference taking place in Dubai, but also virtually on the sidelines of COP28. So everybody's thinking along these lines. And the Office of Human Rights for the UN is also really, really pushing these discussions as well. And so it's a great time to be engaging around this. And I think more than ever, it's an important time to be engaging around human rights and global South, global North relations discussions. So I'll be at COP28 from November 28th to December 13th, specifically working on the gender equality context. And I'll just say that this is also really, really relevant to that work that I'm doing because we have seen a lot of evidence that the climate migration or mobility is especially relevant for women and girls who become more vulnerable to issues like gender-based violence in these movement situations. So that's a little bit on COP28. And yeah, I think that these discussions in advance and leading into are really critical. Thank you.
Awesome. Thank you so much for that context. And go well. And anyone else traveling as well. And hopefully this is helpful to adding some tools to your toolkit and those conversations. I'll just share as well something from our collaborators. Last year, we helped in the drafting of the Kyoto Climate Emergency Declaration, which was the first of its kind, a declaration to COP last year. That was actually built in a climate frontline community and the island of Kiowa, which is a really powerful location to bring together climate activists. And we were humbly serving to draw out some of the legal language in the actual declaration. And I just wanted to highlight a couple of the key demands that, again, a lot of our collaborators in the Pacific are wanting to emphasize ahead of these conversations. One being ending fossil fuel extraction, including subsidies and financing, being really clear on drawing the line there, advancing a safe and just transition to renewable energy. As we just discussed, the just, dignified, and safe movement of peoples being protected by law and promoted in policy. and advancing a separate new and additional financing for loss and damage. So those are some of the many demands in the Kyoto Climate Emergency Declaration, but I think it's important to come back to what climate frontline communities are demanding ahead of COP. And yes, wishing everyone well who's traveling, and yeah, wishing you strength from across the movement in those conversations. Isam, do you have a question?
Hello, thank you so much. I do not have a question, but I just wanted to say that I will be there in COP28. I just landed here in Dubai 2 weeks ago, and today also there's an important event. It speaks about the global climate change and the same issue, and also the fifth industrial revolution. I wish to see you all there, and I think it will be better if there's a kind of a communication or networking channel. It will be easier to gain such kind of information from you. Especially, I consider myself as someone who plays the country. I think most of you have seen what has happened in Sudan last 7 months. I was been in Somalia. I could not manage there. I moved to Dubai, and I do not know up to when I will be able to stay here, because as you all know that in all Middle East nobody can stay with the legal residency. I mean with the immigration rules. Like if somebody stayed for 5 years or 6 years or 10 or even 20, you could not get citizenship, which is very I can say hard for us. So like somebody can look for such kind of issues, and this thing could be discussed in the coming COP. Thank you very much.
Yeah, absolutely. Well, we can have a conversation following this too to follow that up. Citizenship, right of return, all of these questions are alive with our partners as well in the Pacific. So we can definitely share at least what we've learned, and hopefully it's helpful for you as well. I think in terms of connecting folks, feel free to drop in the chat if you're happy for me to share your name and email or any contact information. I can put that in the email that goes out to everyone. And so if you put that in the chat, I'll make sure to capture that and send it off. Otherwise, I'll send an email to everyone. So if you want to be connected with anyone in particular, I can follow that up too. Now we'll open up for a little bit more Q&A in a moment, but I do want to do our quiz. Very exciting. It's my first time using Mentimeter for a quiz. So we're gonna get into it. I mentioned before, let me make this smaller. Here we go. Yeah, can you see my screen? Perfect. So what we're going to do is you can actually go onto menti.com or scan this QR code. It's a very short, very fun quiz. There will be a leaderboard and all of this. And for our winners, you can actually, we'll shout you out on social media if you'd like. And then we'll come back to all of our questions, including Marco's question in the chat, just after this. So scan the code there or go to menti.com and enter this code here. It looks like we've got a few people in. I think I need to go this one. Yeah, cool. We'll just give another moment for folks to sign into this. Awesome. I see 9, 11. 12. All right, we'll get started in just a couple of seconds. Amazing. All right, so they're just a couple of questions and they shouldn't be too tricky, but we'll get into it. So what did we learn from today's training? Quick fire questions as a recap. So we have our code here, everyone's in, and here we go. Love the icons. Question number 1. So the faster you answer, the more points that you get on the leaderboard. Article 6 of the ICCPR defines Which one? We have the freedom from torture, the right to life, freedom to choose one's own residence. Let's see, awesome, awesome. We did talk a lot about freedom from torture, so that's totally fair if you thought that was the right answer there. But yes, Article 6 is right to life, and we don't want to forget it. Very good. All right, we'll go on to our next question here. All right, true or false? Disasters and environmental degradation are grounds that constitute persecution under the Refugee Convention. True or false? Awesome, it is false. That was one of the big gaps in refugee law, and that environmental degradation is not a part of the grounds that constitute persecution under the convention, which was in 1951. So we know that there's a gap there that we need to address. We'll go on to our next question. We just have a couple more. I feel like I'm ready to be quiz master now. True or false? The vast majority of people, of climate displaced people, will move internally within state borders or for only a short duration. True or false? Awesome. It is true. It is true. That's really important in these conversations that we do, even though there's a lot of sensationalism around cross-border migration. It's obviously highly politicized. The vast majority of people will be displaced internally. The reason we focus on cross-border is because of those massive gaps in terms of international law and because of how tricky it is to make some changes. There's a lot of great work going on around internal displacement, which is more related to a separate conversation. But we want to bear in mind the numbers there and sort of what climate mobility looks like broadly. All right, question 4. Here we go. True or false? The right to a healthy environment passed in 2022 is legally binding on states. Awesome. It is false, unfortunately. It is not legally binding, but it can be used as a component of broader international human rights law and connected to arguments made around other rights that are legally binding. I mean, it represents, right, that momentum in the right direction of connecting climate justice and human rights. All right, our last question here. True or false? Dignity is clearly defined in international human rights law. False. Yes, well, it is mentioned many times. It is not clearly defined, which is where our right to life with dignity legal standard comes in to try to substantiate that definition a little more clearly. Oh, this is a bit competitive with our quiz. We have our leaderboard showing up here. Amazing, amazing. We have many winners here. I think we had our list. Sarah won, which is very good. Sarah's on the ICAAD team. Awesome. It sounds like we had a lot of correct answers as well and ties, and it came down to who answered the fastest. But very good, everyone. It's a good way to just check our knowledge and to touch on some of those key key components and key learnings from today, and really appreciate all of your patience and participation in bringing this together today. What I want to do now is just open us up to a bit of Q&A in the time that we have left. And I'll also drop this survey link in the chat if you'd like to do that. In the meantime, here's our survey, and I'll just answer that first question from Marco about which definition for dignity we use in our work. If you have other questions, I see a hand raised, we'll go through those as well, and we'll finish just before the top of the hour. Our definition for dignity, that is sort of the question of the project about how we, maybe I'll close out of our screen share as well so we can see each other. That was sort of the key question of the project and substantiating that. So in the legal standard, as you can see in the working paper and in that advocacy briefing, what we've done is pulled together that it's about life and access to basic necessities of life, including but not limited to water, food, and shelter, security from serious illness or injury, whether physical or psychological. A lot of these things are already underpinned by the right to life, but the component of dignity that we've added is this something that is fundamental to the identity, conscience, or the exercise of human rights of the applicant and of a particular social group to which the applicant belongs, including but not limited to the ability to engage in cultural practices vital to the particular social group. And I will say all of this, it's a working paper, so the project is still developing. This isn't something that we're going to put into a case right away. So really excited to meet many of you that we don't know already. If you'd like to, help shape that definition, that's what we've been working on over the last couple of years, bringing out lived experience from people on the climate front lines, but also adding in that technical expertise of what's strategic in international law. But we can open up to any other questions or comments.
I'll just ask Erin, will there be any other workshops around the release of this paper?
Not that we have planned. This was the big one, and we have a lot of sort of collaborators to follow up with in ways that suits them. So some of those are like Zooms with smaller groups of folks who are connected on certain issues, but no like public formal workshops planned yet. But if there are ideas or groups that you all are connected to that you'd like this to be done with again, we're really, really happy to put that on.
Yeah, I can think of a few, so I'll reach out.
Cool. Awesome. Yeah, we'll flag both the ICAAD newsletter as well as sign up to the GGRC network as a member if you aren't already. I'm assuming many of you are, but I'll put that link in the chat too. And I'll share all of this out over email so that everything is in one place, including that survey link, all the newsletter membership links, and the actual advocacy briefing itself. Awesome, Marco. I'll add you to our list of collaborators to participate in those future discussions. Coming up will be sort of refining everything in the working paper for a more technical sort of legal papers to come out. So that's the direction that we're going. So we will be continuing to have research in our design justice methodology along the way about what that definition should look like. So I'll loop you into that. And if anyone else is keen, I'll also put that in the email as an invitation for anyone who wants to be in those ongoing conversations. But I think with that, maybe we close out a bit early. Ravi, did you have anything else to add?
Yeah, thank you, Marco. I'm going to chase Marco after this to become a member of GGRC too and an advisor. So just a shout out, Marco and I met in South Sudan where I'm working for the Peace Building Fund. He was the Triple Nexus advisor. and he, I think, just left UN, and he has worked in UN for ages. And it's really a privilege to have you here, Marco. Thank you so much. And we'll be in touch. We'll have so many different events, and maybe in the future, maybe Marco could host an event with us on a topic that he's passionate about on Triple Nexus and with ICAAD and GGRC. So thank you so much. And thank you so much, everyone who took out your time. This is amazing. I mean, we had a lot of people who joined in the beginning, and we are the top 14 who were the strongest. We remain till the end. So kudos to us. Thank you so much. And we'll keep you updated in our next events. It might not be exactly on this topic, but topic it is, it will be very much related to the priorities of ICAAD and GGRC. So thank you so much, everyone. Really appreciate it.
Awesome. Thank you all. And thanks for taking the time in this busy time of year to do some learning together. And really, really happy to share and share out our advocacy briefing and working paper with you all as our first audience. And I'm sure we will all meet again soon.